a transcript, they're required to file the transcript within so many days of it being ordered, if it's, let's say, ordered for an appeal. Okay, once that transcript is filed, the court, so the appellate court, the district court, parties will have access to that transcript, but the general public and other people, even other Iowa attorneys, will not be able to see that. The court reporter will have gone through the transcript and electronically marked items that may be protected information. Say a child's birth date, social security number that was stated during the hearing. The court reporter, along with the transcript, will file what's called a notice of transcript redaction. Then the parties will have 10 days to go through the transcript, look at what the court reporter marked as potential protected information, and then file within 10 days your notice of whether you agree with that or whether you think there are additional information that needs to be redacted or whether he or she redacted too much. Okay, so until that fight has been, or until there's been an agreement that the correct information or hearing's been held, the correct information's been redacted, that transcript will not be made available to the general public until the redaction process has happened. And this, a similar process will go with exhibits. When exhibits are used, let's say electronically by the court, they're not going to be made immediately available to the public until some redaction period has gone through. Again, if you're submitting a financial document and you don't have to have a full account number on it, I strongly encourage you to redact before you submit it to the court so that there is no issue that this information is going to get out. Now we have some special issues in criminal cases. Okay, if you have warrant or similar documents, you're going to the judge to have those signed during office hours. It's encouraged to do that electronically. There may be situations where the police are calling it in, essentially, and it just may not be feasible to do it electronically, but for the most part, we're trying to get everything done electronically if we can. After business hours, the officers are knocking at the judge's house. We're going to take whatever we can get. If they happen to have an electronic capability so the judge can change it on whatever notepad or whatever the officer has and e-file it, or it can accept the judge's signature, that's great. Otherwise, it'll be done in paper and scanned in later. Initiating documents. Trial information is going to be electronically presented to the judge. If the judge approves them, they'll be filed. If the judge does not approve them, they'll be returned to the county attorney. Documents requiring oaths, application, if I know where I am here. Oaths, affirmations, or verifications, like a uniform citation or complaint that requires a signature be made under oath, affirmation, or with verification, can either be scanned in and filed, or if they're able to, and this language on B comes directly from the code, signed by electronic process that accurately produces a signature, and you can read it from there. But if the officer has one of those that electronic capability, they're going to be able to just send it in that way. Otherwise, it will need to be scanned. Again, this is a pretty big, when you think about all the traffic tickets and things that come in, this is a pretty big issue. So it will also be submitted electronically. How do you get a defendant's signature on a document when it's required? And there's recognition of the realities of practice in court. And in my day, we call this cattle call court or high volume court. There are times if you represent criminal defendants, you may only see your client at the courthouse. And it's kind of hard to get them to come to your office and electronically, or sign something and scan it in and get it to the courthouse. You may be lucky if they show up 10 minutes before a hearing so that you can get this done outside the courthouse door. And so there is that recognition that you may need to have them sign it with pen on paper, and it'll be scanned in at the conclusion of the hearing or at some point when that's submitted to the court. Now, the defendant may also electronically sign it by use of a computer tablet or similar technology that can capture their signature and apply it to a document. And a third way is if the defendant is a registered filer, they're going to be able to use their username and login password to go ahead and electronically file using their signature. Any one of these three methods works. Okay, special issues in juvenile cases. Again, this is very similar to the warrant that we talked about in criminal cases, but when you're having emergency applications, if it can be done electronically during business hours, that's certainly the preferred method, but sometimes those emergency removal orders come at midnight and it just may not be possible, and in those cases it could be scanned in or any other method that gets the job done. Signatures of parents, guardians, custodians, children, or adults within the juvenile court jurisdiction, again, can be placed on the document the same way that a criminal defendant's can. One of those three ways, either sign in paper and scan it in, the use of computer, tablet, or registered filer. Plea agreements are the equivalent. There are times when the judge is going to want to look at that during the plea hearing. You may not want it to be filed if the plea goes south, or you may want it to be filed. So the rule actually says that written plea agreements may, not shall, may be presented to the court, but they need not be filed prior to plea proceeding, and that you can choose to have them filed after. I mean, it just depends on the nature of your case and the issues there. I think we're going to switch over to David Beckman, unless you want to take a little break for questions on this aspect. And if not, there will be time for questions after David talks about how to work this in your office. Yes?
Is this going to be connected anyway to Iowa Courts Online?
Not really. That still exists, so you can still use, and that will continue to exist. So you'll be able to go there and look up cases. And in fact, as an Iowa attorney, that might be one way for you to say, look, I know that there's a case out there, and I know the guy's name, but I don't know the case number. And you can go in and find the case number and the parties' names, and then go in and to the eFlex system, and then you'll be able to input the case number, the party name, and then go look at those documents online.
Will it down the road say whether it's been filed electronically?
On the Iowa Courts Online?
Yes.
Yeah, we'll show you those cases that are e-filed. We'll let you know by some EDMS on them or something like that, so you know which ones are.
All right, thank you. Talk about
Thank you very much. Let's have a round of applause for Donna. I don't think too many people really realize how much work that Donna has put into this over what a period of time. I looked at my electronic file, and my first documents on EDMS were back in 1997. I don't know if that's when it really started, but that's the first awareness I had of any of that. And it was talked about extensively in the courts in the 21st century. It was back in 1999. If you read that study today, you find much of this in that document. People talk about this as wild, new technology. Quite frankly, from a technological point of view, there's nothing new here at all. When we talk to the vendors and we say that we've got an issue here about a rule and how we're going to work it with the system, they'll say, well, do you want to solve it like we did in Utah this way, or do you want to do it like we did in North Carolina that way, or do you want it to do it like we did in Florida and do it some other way? And so it really is not rocket science. I mean, I understand it's new to many, many people, but on the other hand, the technological piece of it is certainly not new. Minimum requirements. When the committees first started meeting on this, one of the key things we talked about is we wanted to keep the technological requirements absolutely to a minimum. I'm asked all the time, well, what new equipment do I have to buy? Do I have to go out and buy this and that? And intentionally, we kept this to an absolute minimum. And if you look at this, you'll see that you need a computer with an internet connection. You need a